Hello friends, in today's session we are going to discuss the case Vodafone International Holdings B.V. versus Union of India and others. Reference SLPC number 26529 of 2010. First, let's briefly understand this case. In this case of Vodafone International Holdings B.V. versus Union of India, Vodafone challenged the imposition of capital gains tax on a share transfer and took place between into non-resident companies outside India in 2007. Hutchison Telecom excited the Indian telecom market by selling its 67% stake of Vodafone, which Indian tax authorities considered taxable. The Bombay High Court ruled in favor of imposing the tax, but the Supreme Court overturned the decision, stating that the transaction did not involve the direct transfer of assets in India and that Section 91I of the Income Tax Act did not apply. The Supreme Court deemed Vodafone's action as legitimate tax planning and ruled that the Indian government could not impose the tax. Now let's study this case in details. Answer: Vodafone International Holdings B.V. Petitioner versus Union of India and others. Respondent. Reference SLPC number 26529 of 2010. Subject: in this case, Vodafone International Holdings B.V. challenged the authority to levy capital gains tax on the transfer of shares between two non-resident companies outside India. The Supreme Court ruled that this transaction was indivisible and applied only to income earned from assets located in India. Therefore, Vodafone was not required to pay the tax. Case fact: in 1999, the Indian government abolished the licensing system, leading to significant growth in the telecom sector. After 1999, telecom companies experienced one of their best growth periods during this time. Hutchison Telecommunications International Limited (HTIL), the parent company, established a subsidiary in India under the name Hutchison Essar Limited. HTIL held a 67% stake in Hutchison Essar Limited, which was controlled through a holding company, CGP Investments Holdings Limited, based in the Cayman Islands. In 2007, Hutchison decided to exit the Indian market. Around the same time, the UK-based telecom giant Vodafone International Limited expressed its desire to enter the Indian market. Consequently, an agreement was reached between the two companies under the CGP Investment Holdings Limited decided to transfer its 67% stake in Hutchison Essar Limited to Vodafone International Holdings B.V., a Netherlands-based holding company of the Vodafone Group. In exchange, Hutchison received $11.1 billion. At the time of transaction, both parties believed that the Indian government could not impose capital gains tax because the transaction took place between two non-resident companies outside India. At that time, there was no legal provision requiring a company to pay capital gains tax on the indirect transfer of Indian assets. However, when the Indian tax authorities becomes aware of this transaction, they issued a notice on 6/8/2007 under Section 165 of the Income Tax Act, questioning why Vodafone Essar Limited should not be considered as a tax deductor. Additionally, the Assistant Director of Income Tax Mumbai issued a notice under Section 21A and 21(1)(a) stating that Vodafone should be deemed a tax defaulter for failing to deduct tax at source. Dissatisfied with these actions, Vodafone filed a special leave petition on 19/9/2007 before the Bombay High Court, arguing that the tax authorities had no jurisdiction in this matter. The Bombay High Court concluded that the transaction between Hutchison Telecommunications International Limited and Vodafone International Limited involved not only the transfer of controlling interest share but also other rights and entitlements which qualify as capital assets under section 214 of the Income Tax Act. The court ruled that even if the transaction did not occur in India, it was related to an Indian assets, allowing Indian tax authorities to claim capital gains tax as per the applicable laws. Furthermore, the court clarified that section 91I applied to this case because it covers income directly or indirectly arising from any business connection or the transfer of any asset located in India. The court emphasized that if an arrangement demonstrated a nexus with India, section 195 of the Income Tax Act applies, requiring tax deduction at source. The Bombay High Court also noted that the Income Tax Act 1961 has extraterritorial applications, and if a transaction is proven to have a connection with India, the provisions can apply even to non-resident. As a result, the Bombay High Court dismissed Vodafone's petition and affirmed the jurisdiction of Indian tax authorities. However, the court also stated that Vodafone could argue before the tax authorities that it had a reasonable belief that tax deduction at source was not applicable, which could exempt it from penalties. Following this judgment, Vodafone appealed to the Supreme Court of India against the Bombay High Court's ruling. Supreme Court's decision. The Supreme Court's ruled that the transfer of shares and the transfer of controlling interest were not separate transactions but rather an inseparable parts of the share transaction. The court further clarified that the controlling interest is a contractual right, not a tangible property, and thus acquiring shares cannot be used as a basis to impose tax on controlling interest transfer. The Supreme Court held that Section 195 of the Income Tax Act applies only to resident and does not have extraterritorial jurisdiction. Since this transaction occurred between two non-resident companies outside India, it had no direct nexus with India. The court also clarified that Section 91I applies only to the direct transfer of assets located in India and does not cover indirectly earned income. The Supreme Court observed that Vodafone International Holdings actions fell within legitimate tax planning similar to the tax structure used by many offshore companies in Mauritius and the Cayman Islands. The court held that the corporate will could only be lifted in case of same transaction or tax evasion, but in this case the transaction was genuine and made in the interest of investors. Therefore, Vodafone was not liable under Section 163 of Income Tax Act. Thus, the Supreme Court overturned the Bombay High Court's decision, ruling that the Indian tax authorities had no right to levy capital gains tax of approximately rupees 12,000 crores on Vodafone International Holdings B.V. and Vodafone was not required to pay the tax. Please watch full video, share and subscribe to the channel. Thank you.